All rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. At the outset, I will say if anybody feels comfortable doing so, please feel free to remove your masks for the purposes of your time here. You will notice we are 2 and not 3. Judge Brown was unable to be here in person this morning, but he will be viewing the argument online and participating in this decision. Now, we are here for oral argument in CV19-0854 Cooper versus Youngtown. As you probably are familiar, we record and live stream these proceedings, and so we would ask you to give your name and the name of your client at the beginning of your remarks. According to current protocol, you will be arguing from your counsel table. Other things remain the same. You each have 20 minutes. If you'd like to reserve time, that's up to you. Obviously, the clock is on the podium, so do what you need to do to be able to see that, and we'll try to give you signals, signposts here and there about what time you have remaining. Keep in mind, we've read your briefing, we've reviewed the record, we discussed the case in conference this morning, and with that, please feel free to begin.
Good morning. May it please the court, counsel. This case involves clear error by the trial court in that the trial court confused the identities, the contractual identities of the parties. The trial court also stated that because this is an arbitration agreement, both parties necessarily had to sign it in order for it to form. And finally, the trial court ruled that without a signature by what he called the parties who were the offerees, which is incorrect, that the contract could not be enforced. For many reasons and very clear reasons set forth in the briefing, those are clear errors of law and require this court's consideration and require this court to address those errors.
Counsel, what do you make? So I tend to agree in that the vast majority of arbitration agreements, at least those that I've come across, only require the signature of one party. But the language of this arbitration agreement does raise some questions. There's the heading that says optional. There's a clause that talks about both parties giving up their rights. Can you talk about why those pieces of language don't change the nature of this particular agreement?
Absolutely, Judge Perkins. This particular agreement does not say that both parties' signatures are required. Nowhere in the agreement does it say that. It simply has a notification and an acknowledgement that by their signatures, the parties understand that they will not be going to court and that they will be arbitrating the agreement. In all of the cases cited by appellee's counsel, there was clear language that said specifically, this contract will not form unless there is signature by both parties. That is not the case here at all. And for that reason, the condition precedent argument that was raised for the first time on appeal by appellee's counsel, it was not raised at all in the trial court. It was not part of the trial court's ruling. But that issue, that condition precedent issue, has to be viewed through the Arizona law that condition precedents are not favored. And here, it does not even purport to establish a condition precedent at all. If you look at the arbitration language in the first paragraph, it specifically states that this is entered into between the facility and resident, and the scope of arbitration covers all issues. And then it goes down and specifies language just for the resident. It says in paragraph 2, the resident acknowledges that he or she has the option of not signing the arbitration agreement. It doesn't say the parties acknowledge that they don't have that they have the option. of signing the arbitration agreement. Most importantly, and really what everybody looks at, is this language right above the signature line. That language where it says, quote, "Notice by signing this arbitration agreement, you acknowledge that you understand the terms of this arbitration agreement. Further, by signing this arbitration agreement, you are agreeing to have any claims arising out of any dispute between you and the facility, including those alleging medical malpractice, decided by arbitration, and you are giving up your right to a jury or court trial," end quote.
So the right to a jury trial is pretty bedrock kind of right in this country. Why shouldn't courts require both signatures when we're talking about that kind of a right, especially given the nature of this agreement? It's not like it's a difficult task.
Right. Consistent with all of the case law that I cited to the court, the FAA's purpose is to make sure that arbitration agreements are encouraged. And this court recently decided a case, the Security Alarm Financing Enterprises case. In that case, this court held...
You have 15 minutes.
Okay, thank you. This court held under the FAA that even in construing the language of an arbitration agreement, any doubt should be resolved in favor of arbitration. That's a 2017 case decided by this division.
We're not really construing the arbitration agreement. We're trying to figure out whether one was entered.
Right.
So now in doing that, you're asking us to ignore, look at this other language, but what do we do with the fact that there was a signature line there? That's pretty plain, demonstration of requiring a signature. Most people don't put a signature line unless they expect the parties to sign it.
I think that we can then look at all of the case law, even the case relied upon most heavily by Appellee's Counsel, the SK Plymouth case. In that case, there was a signature line on the arbitration agreement as well. And Judge Gass, the court held, it doesn't matter, the intent of the parties controls. The party seeking to enforce the arbitration agreement didn't sign it. And nonetheless, the intent was found. And why was it found? The same principles existed in that case and the same facts as exist in this case. The arbitration agreement was presented in the first place to the party who didn't want to arbitrate, and they signed it. Then, after that, they maintained it in their file for all of that time, and then they moved to compel arbitration. We have all of those situations here, plus more. We also have an opportunity for the parties to rescind the arbitration agreement, and that's the Trout case. There was an opportunity for 30 days to rescind it if they wanted to do so. That was not done. And the resident, Mr. Bushel, continued to receive the benefits of the care that he was receiving at the facility, and his insurance company paid for those benefits. All of those situations show that there was
That
an
latter point,
intent.
the care was not contingent on signing the arbitration agreement, was it? So I'm not sure that can be considered a...
It wasn't contingent, but they continued to receive the care after signing and not rescinding the arbitration agreement. So the arbitration agreement was in place, like in Trout, where they continued to pay for services and did not rescind it, and that was held to manifest an intent to arbitrate. Truly, the presentation of this agreement to the wife and the issue of authority, really, I don't know how fully it is before this court, but I'll certainly address it if need be. The presentation of it is a manifestation of intending to arbitrate. And then the motion to compel arbitration without filing an answer, without doing anything else, that's a manifestation.
And I don't think that is before us. We're very narrowly focused. But let me ask you this. The arbitration agreement is part in context of the entire admission packet, right?
That's correct.
What does the admission packet say as far as signatures? Does it say it has to be fully executed? All parts need to be fully executed one way or the other to be enforceable?
No,
So there's no requirement, is there any requirement in the admission packet that the facility have to sign? In other words, like a real estate contract.
Right.
This is only going to be valid if both parties have signed it. Is
No,
there
there-
anything like that in any other part?
there is not. There's not one thing that says that both parties, and particularly the facility, which is the most relevant thing, has to sign for any of those. The admission agreement, and there were informed consents, there were different notifications and all of that where, many of those documents were signed.
And now that obviously can cut both ways. And what do we, and I guess there's no question, it just comes back to the fact that there is a line here for the signature, even though it's not anyplace else.
Right, and there is not case law that says that a blank line not signed under the FAA means that there's not formation. There is case law that says that if the contract itself says specifically both parties have to sign, then both parties do have to sign. But that's not the case here. And with that, I'll go ahead and reserve the rest of my time.
Good morning, Your Honors. My name is Jeffrey Victor. I represent the personal representative of the estate, Michael Buchel. Her name is Paula Cooper. If it pleases the court, what Your Honors need to look at is the four corners of the document. The four corners of the arbitration document. I won't call it an agreement because there was no agreement reached. Interesting enough through this case, in terms of the motion to compel in the lower court, in terms of the reply, in terms of the appellant's opening brief and the appellant's reply brief, in all due respect, not once has the facility explained away why they went to great lengths in putting a signature line on this document. They are the drafters of the document. They went to great lengths in putting two signature lines that are of relevance. One for the administrator or the designee to sign as a form of acceptance. The other one for the so-called legal representative, agent, person in authority to sign on behalf of the patient. Okay.
Let me ask,
Yes.
you
yes.
said something very important. You said to sign as a form of acceptance. But it doesn't say that. Isn't it possible to also construe it as just to sign it as a witness kind of thing? That I'm the one who watched this person sign?
No, that's a very good question, Judge Gass, because if you look at the document, there are at a minimum two places where the drafter facility went to great lengths in saying the party or parties, okay, and collectively the parties, as it's referred to in the document, is the facility and the patient, okay? It says, by the parties signing, by the parties signing. They went through great lengths to make sure that the document on its face says, by the parties signing, they're waiving their rights to a jury trial.
What is the rest of it? By the party signing you. I don't have a copy of it in front of me, and I apologize. What does the rest of that sentence say?
On the first page of the agreement, it says the parties understand, okay, both parties, the facility and the patient, by signing this arbitration agreement, claims as between the resident and the facility cannot be litigated in a court of law or equity before a judge or jury. It's clear on its
But
face.
we have to read that language in conjunction with the subsequent all caps language that says, by signing this arbitration agreement, you, resident, acknowledge that you understand the terms of this arbitration agreement. Further, by signing this arbitration agreement, you are agreeing to have any claims arising out of any dispute between you and the facility. If we're saying that the facility also has to sign, it's nonsensical. Between the facility and the facility?
No, Your Honor, in all due respect, page 2, where it says notice, it does not say you resident. It says by signing this arbitration agreement, you acknowledge that you understand the terms of this arbitration agreement. And then below that is the signature lines for
Right,
both
so the
parties.
reason that I read the whole thing
Sure.
is because at the end of that long sentence, it clarifies that the you is not the facility. It says between you and the facility.
I understand that language, but where it starts out, it says by signing this arbitration agreement, and then it says you and the facility. It still has a signature line right below that paragraph for the administrator or designee's name, and it's left blank. And they drafted the document. They went to great lengths to make sure that there would be a signature line.
So how do you distinguish the cases that your colleague up here mentioned, the SK Plymouth and the Trout case, where there, I think it was in Plymouth that there was a blank signature line and the court nonetheless enforced the arbitration agreement? Or Trout, where the court, as in virtually all other cases, looks to the manifested intent of the parties, not something so specific as whether both parties signed?
Well, we obviously, when we have something that's clear on its face, we shouldn't, in all due respect, read into the agreement. It's clearly unambiguous. Okay, it clearly says by signing the parties.
I guess what I'm trying to do
Sure.
is direct you to the case law. Can you tell me what is your best case that shows us an example of a court requiring both parties to sign an arbitration agreement in order to enforce it that did not contain condition precedent language?
The best case, or one of the cases that I can refer the court to, is the Premier, P-R-E-M-I-E-R-E, Chevrolet versus Hedrick case, where the court found in that case that specifically the dealership needed to sign and accept the sales order, and they did not. Okay.
Do you have an arbitration agreement case?
Yes, I think.
Was there an arbitration clause in that sales order?
Yes, that's what they were. That's what the issue was about, Your Honor.
Okay.
Yeah.
And did that arbitration or sales agreement contain condition precedent language?
I believe it contained language that the dealership had to sign, or a signature liner had to sign, and they did not.
Okay.
Which is exactly what we have here.
But I'm going to beg to differ there. Isn't it that the dealership had to sign for that to become a binding contract, which included an arbitration clause? And in that case, the dealership didn't sign, so there was never any binding contract overall, which included an arbitration clause. So there is a difference between the two cases.
Well, there's no contract in that particular case. There's no ADR contract in this particular case for the same reasons. There has been some discussion that the facility was the offeror and that the patient or the patient's representative was the offeree. That's contrary to the wording in the document that was drafted by the facility, because it says optional for resident and facility. So the mere presenting of this optional agreement is not a firm offer, which is what the facility would want you to believe. It's optional. They still, even though...
To the extent that we're looking at that optional
Sure.
language in that fashion, isn't the facility's presentation of the agreement evidence that the facility has exercised that option? I mean, if
No.
the facility was not intending to exercise the option or choose to participate in the arbitration agreement, why would they make it a part of the packet?
That may have been their intent, but it's not, from reviewing the document, solidified as such. It's like going to a real estate broker, they give you a pre-printed form, and you want to write up an offer on a particular house. Okay, you are the offeror who's making the offer to buy this house, even though it's on a pre-printed form that's supplied to you, it has to be accepted by the seller of the home. If the seller doesn't accept the the offer, and in this case, the patient would be the offeror, the facility would be the offeree. The facility never indicated acceptance by their own terms, which states by signing of the agreement, the parties agree, and has a signature line. They never signed. They never signed. And this argument, and if what I'm hearing is some type of a detrimental reliance argument or an estoppel argument.
Let me ask you though, I want to
Sure.
go back to the optional before you move on.
Yeah.
Isn't it also a fair reading to say it's optional in that it is purely optional to the person who's being admitted? You can sign it, you don't have to, there's no consequence if you don't. This is an optional provision that doesn't necessarily indicate that the offerer is making it optional on their side. In fact, the agreement expressly says, you are the one who has the option and we won't take any action either way. In other words, it is an optional agreement as part of this.
It's optional, and the language states optional for resident and facility.
Right.
It's optional on both sides. Okay, and they never accepted it, in all due respect. Even though their own agreement says, by signing of this agreement, the parties, facility and the patient collectively as the parties agreed to waive a right before a judge or jury. Facility never signed it. And the mere fact
Let me
that,
ask you,
sure,
because in a lot of agreements, usually the signature is only required for the party that's bound. So in this case, one of the parties signed it, and that's the parties that's being bound. Is your argument that somehow this is unconscionable now because the facility didn't sign it, therefore they're not bound by it?
no, I think this agreement, the way it was written, was for the benefit of both the facility and the patient if both parties signed it. Okay, if the patient, if the facility saw fit on an accrued debt, if they had signed the agreement, they could sue the patient or the patient's estate or bring a claim through arbitration. This agreement is mutual for both sides. Is the way I read it. It says by the parties signing. They want the court to redraft the agreement.
You have 9 minutes left.
Thank you. They want the court to redraft the agreement, take out the signature line, and take out the language in a couple of paragraphs where it specifically says by the parties signing. Okay, we can't do that. This is the agreement. You have to look at the four corners of the agreement, and we need not go beyond that. And that's exactly what Judge Campanella looked at. The first issue is there a meeting of the minds? Is there a contract? Is there an agreement? Both parties need to sign the agreement. Both parties have signature lines to sign the agreement. The facility failed to do that.
Let me ask you just a follow-up question to one I asked other counsel.
Sure.
Which is this is part of a larger admission packet? Do you agree that there's no place else where they're required to sign? There's no overall, and where I've seen, I'll tell you why I'm asking. I've seen this in other contexts where the arbitration agreement is just one piece of a much larger agreement, and it's referenced as such. It doesn't seem to be the case here. That this is not part of an agreement that says, the parties both need to sign this whole agreement for the patient to be admitted.
Well, this is a standalone agreement. It was on page 28 and 29, I believe, of a 30-page admission document. But the testimony from Angela McMurray, the facility rep, is that she did sign off on some of the earlier documents, the earlier pages in the admission packet. So it's not like she signed nothing. She did sign earlier forms.
But I think Judge Goss is asking, is there language that required that counter signature from the facility anywhere else in the agreement?
You mean for the earlier pages?
Anywhere else in the agreement
Yeah,
is there
yeah.
language?
Yeah. As I stand here, I'm not aware that there's specific language that requires that. All I can tell you from the testimony is that she said she did sign off on some of the pages that were earlier in the admission packet.
I want to clarify something. So let's just assume for a moment that we disagree with the Superior Court's finding about the requirement of the dual signatures. Ms. Cooper has raised a number of other arguments. Do you agree with your colleague that those are not before us? So if we were to disagree with the Superior Court's finding, this would need to go back to the Superior Court for further determination on those arguments.
Well, the issue of unconscionability was raised in the response to the motion to compel. It was not addressed because right off the bat, the judge looked to see if there was a valid enforceable agreement, and from the four corners of the document and the lack of signatures and the wording of the document by parties signing, Judge Campanella, rightfully so, said, no, there's no meeting of the minds.
Right, if we
Right.
disagree with that, the other arguments, are those arguments that we would take up, or do we need to remand?
I think you can address the unconscionability arguments because they have been preserved, at least in terms of the appellee. They were addressed in our brief. And if you
But-
want me to talk a minute or two on that.
I guess I'd like some clarification of that, because my understanding of the unconscionability arguments are that they center on these questions of whether Ms. Cooper actually signed. Did she actually sign when it was just her first name? She did not sign the other. So what beyond, those are clearly fact issues. Beyond those, what is something that we would take up?
That's a good question. So Ms. McMurray said that she gave the patient or the patient's wife the admissions packet, and she said, here are documents that need to be signed. That's unconscionable, because if you're truly saying that this is optional in nature and the patient doesn't have to say it, it's unconscionable to give them 30 pages and say, here are documents that need to be signed.
But is that a finding we can make in the first instance, or would that, the Superior Court didn't address that, correct?
Correct.
And so you're saying that's something that we could address? in
Yes,
the first instance?
it's in the record. The other issue is, if you look at this two-page document, the drafter starts talking about how it's the philosophy of the facility to give independence and freedom of choice to the residents, and it is the legislature's intention that residents desire to resolve any claims as described herein quickly and less formally than in a judge or jury trial. In all candor, they have no business speaking on behalf of the legislature, other than trying to lure the resident, the patient, into saying, well, if the legislature thinks this is good, I'm going to sign off on it. It's inappropriate language. It's unconscionable language to put that in there. That's just a seal of approval from the legislature. The issue of whether there is a estoppel or detrimental alliance because they took the document, all they did is they took the document and they put it in the facility file. I think Judge Goss, you brought it up. Whether the document was signed by the patient or the patient's spouse, they would still provide services. They didn't do anything extra relying on this document. They took the document and put it in the file, and they would still be providing services whether the document was signed by the spouse or not. So you can't make the argument, in all due respect, oh, we detrimentally relied on this document and the wife signing it,
You have
and
3
she should
minutes.
be stopped now. They didn't do anything extra. They didn't give anything extra by virtue of relying on this document. They didn't rely on this document. They took the document back and they put it in the facility file. And unfortunately,
Aren't these arguments that you should be making to the Superior Court to make that finding? They saw the witnesses, observed everything, and then we can take that up in due course if it comes up again. It doesn't seem like it's an appropriate thing for us to do in the first instance because the Superior Court didn't.
well, the only reason I addressed that, Judge Goss, is because, in all due respect, appellant's counsel made it sound like they relied on this document. And that's the only reason I brought it up.
That's fine.
In all candor. The language in the agreement is pretty clear. And you cannot now come back and say, well, we didn't sign off on the signature line that we put in there for the facility administrator or the rep, and we'll ask the court to take that out and not give that any consideration. they have to live with what they put in the agreement. And they didn't sign off on it, and there's some discussion over whether or not who's the offeror, who's the offeree. But regardless, it says clearly by signing the agreement, the parties waive their right to a judge or a jury trial. The facility did not sign that. So if the facility did not sign that, we don't have a meeting of the minds. We don't have an agreement here to waive a judge or jury trial. And it's very clear, and that's what I believe that's what Judge Campanella looked at and said, there's no agreement here. They didn't sign off on it. The language in the agreement requires it. The signature line.
You have 1 minute.
Thank you. The signature line requires it, and they didn't sign off on it. And I'll ask the same question again. Why did they put the signature line in there for the facility administrator or the designee to sign off on if they take the position it wasn't necessary? They put it in there because they wanted it, this optional agreement, and it says optional for resident and facility. They wanted it to no longer be optional and to be binding between both parties. Thank you.
Counsel?
Thank you. Addressing first the issue of the best case that Appellee's counsel had, he was asked, what is your best case? And he cited, I believe, the Premier Chevrolet case. And Judge Goss, I think you saw this, that case specifically did say, without equivocation, and it was a requirement, unless this is executed, it will not become a binding contract. With respect to the exercise of the option or the opt-in and the issue that Mr. Victor keeps raising about us being the offeree, this arbitration agreement was presented to the resident. That presentation in and of itself showed intent. Is there a signature line for the administrator or the designee? Yes, there is.
Do we have to get into the intent argument because it's either, the signature is either required or not? And then beyond that, we're getting into fact issues.
Actually, yes, we do have to get into it for the purposes of being consistent with the FAA, the Federal Arbitration Agreement, and also the Arizona Arbitration Agreement. Both say that they require something in writing. Neither says that it has to be signed by either party. And Judge Goss, you raised an important point, and that is normally, under normal contract law, if it's signed by the party to be charged, then that in and of itself is sufficient. The other party does not have to sign. That's a normal contract law, but under the FAA, it's even more lax than that. Even the plaintiff doesn't have to sign, and that was the Trout case, where the plaintiff didn't sign, but all of the conduct in accepting the benefits and the services and paying for them was there, and so it does manifest intent. And I think under Taylor, Your Honor, that's the main point in all contract cases, but it's refined under FAA cases. And that would again go to this court's recent decision in security alarm financing. The fact is that there just simply does not have to be a signature to make a binding agreement. And if there's not one, and I'll go back to the case that Mr. Victor relied on most heavily, he didn't even raise that as his main case, but that SK, I forgot the last name of it, but it's the SK Plymouth case, the SK Plymouth case. That case was exactly like this case. There was a signature line for the party who was moving to compel arbitration. That was completely blank. And under the FAA, and it was a Texas case, it was decided that the intent manifested by all of the things that we've already discussed was sufficient, and there was contract formation. And every single case, other than those that said specifically, this will not form unless you have a signature, every single case that we pointed out is like that. And
Counsel, let's say we agree with you. Can you address the question about what other issues, if any, we can or should take up versus remanding to the trial court?
Yes, it should be remanded. If you look at the court's order, he specifically said, I'm not even getting to the authority issues relating to what was discussed because I'm finding that there is no contract formation. So since there was no contract formation, then all of those issues, I would agree. I mean, I'd love to have this court just decide them, but the bottom line is, I would agree that they should go back to the trial court. And it's interesting that Mr. Victor argues to the contrary. He's the one who requested an evidentiary hearing. Not only was there not an evidentiary hearing, there was not even oral argument on this. This was decided without oral argument and without an evidentiary hearing. And unless the court has further questions, I don't have anything further. Thank you very much.
Thank you for your arguments, counsel. We'll take the matter under advisement. The court will stand in recess to reset for the next case.